It is my pleasure to introduce today's seminar speaker, Bibiana Law. And Bibiana is currently a scientist in my team. She assists with writing and submitting grant proposals. And she also assists with many of the business as well as intellectual property related aspects in my lab, such as responding to the lawyers regarding office actions during patent prosecution. And she also assists me with responding to the industry regarding contracts, research agreements, and reports. She is also the CEO of our newly formed UA startup, Phytocentric Solutions LLC. I am happy to say that Bibiana is our own graduate. She got her PhD from the Soil, Water, Environmental Sciences Department, currently the Environmental Sciences Department at the University of Arizona. And she got her MBA also from the University of Arizona from the Eller College of Management. And she has some unique expertise, even though, she's an environmental microbiologist. She has her Bachelor of Science in Dietetics and Nutrition from McGill University in Quebec, Canada. So she comes with a lot of unique experience, bit of nutrition, microbiology, and she also has experience in food safety because she worked in Dr. Lynn Jane's lab. And she has a lot of experience, filing patents and so on. So she will be talking to us today about her own experience with regard to innovation and entrepreneurship as a UA employee. She has issued patents as well as pending patents, both in the US as well as internationally. And she has been an inventor at the University of Arizona. She works very closely with TLA. And she received their I-Squared Award for Innovation and Impact as an inventor in 2016. So today she's going to educate us about entrepreneurship as well as innovation, specifically with regard to food safety. She'll give you a lot of her own experience, and she'll touch upon a little bit on the startup Phytocentric Solutions, which is mainly focused on food safety. So let's welcome Bibiana. And before she begins, a few housekeeping things. Just to save bandwidth, please unmute yourself and also turn off your video. Once Bibiana is done and she takes a pause, I will moderate the Q&A session. You can post all your questions as we go on into the chat feature so that I will read the questions to her and Bibiana will be able to answer the questions. You can also come on video, unmute yourself. If you want to, ask questions, you're welcome to do that too when we take a break for, Q&A, and we will go from there. So thank you again so much, Bibiana, for taking the time to talk to us, and it's all yours.
Thank you. Good afternoon. Can everyone hear me? Well, yes. Okay, perfect. Thank you everyone for joining today. As mentioned by Sana, I'm currently a scientist on her team, and we've recently formed a UA startup. I will be introducing Phytocentric Solutions LLC later on in the presentation. But I will start with some background and the experiences I've had here at UA, focusing on the inventor side first, and then some details on the founder side. So as an inventor, I'll go over UA's intellectual property process in regards to disclosures and provisional patent applications, non-provisional patent applications, claims, office actions, notice of allowances, as well as asset development funding, UA's distribution chart to inventors. I'll switch over to focus on the founder side and talk about NSF codes, as well as conflict of interest requirements and licensing agreements before I introduce Phytocentric Solutions, or PCS. In terms of a bit of background, as Sana mentioned, my Bachelor's of Science is in Dietetics and Nutrition from McGill University in Montreal, Canada. I was introduced to commercial food safety at that time. McGill is unique in that their internship is included in the degree. So one actually graduates as a registered dietitian rather than having to look for one or look for an internship after graduation and then becoming registered. So all students that they accept into their program go through 40 weeks of internship staggered over 3.5 years. So I got to work and learn from many wonderful professionals and institutions. I worked as a clinical dietitian in the hospital, but also with the production and distribution of food in the hospitals, as well as in the community. So I do have wonderful memories of, following the hospital tray to the patient who is receiving, for example, renal care or on the cardiology floor, or if it was tube feeding, then understanding that process. In terms of community, I remember following Meals on Wheels from production in their kitchen, whether it was in like a church or school to delivery, usually to the elderly. And it was a lot of fun. And Montreal is such a beautiful, beautiful city to be in, especially in the summer. It's also where I met my husband. And all along, food safety was key. So, such as in terms of temperature and storage and contamination issues. In terms of my PhD, I started in Chuck Urba's lab, who is in the soil, water, and environmental science department. I transferred to Lynn James, who was in veterinary science and microbiology. But my degree is from SWES. My first introduction to patents was in Lynn's lab, as my dissertation was on the pathogenicity of Campylobacter from broiler chickens. So my work focused on the reduction of Campylobacter, which is a common foodborne pathogen in poultry. And, it doesn't cause chickens any issues because they naturally carry Campylobacter, but the transfer to humans causes us harm. So vaccination in chickens. While working for Lynn, I got my MBA from the Eller College here at U of A because I love business schools today. And Lynn and I wanted to start a vaccine company. We did start one in 2012, but unfortunately, as some of you are aware, since Lynn was the chair of the Food Safety Consortium in 2012, he passed away unexpectedly in late 2012 in November. So it is good to see that the consortium is doing well today. I originally was going to list and talk about patents, but then I realized that it might sound like mumbo jumbo or just gibberish. So I'm going to also go over the UA intellectual property protection process as I go along. It used to be that the goal for universities was to publish, but I think in today's environment that it is critically important to move research to real world impact. And the funding and the support today is there. So it's a great time for inventions. It was a lot harder in 2006. The first step at UA is to report an invention via disclosure to Tech Launch Arizona. So Tech Launch Arizona is the commercialization arm of UA and assists UA inventors, which are faculty, staff, and can also be students, in protecting their inventions, whether it's a technical contribution or a method or software. In my case, back then, it was a Campylobacter vaccine, or in the case of phytocentric solutions, today, it's a natural plant-derived sanitizer. So the disclosure is simply a form, which is quite brief. It's a title, summary, detailed description, and any potential public disclosures. So what is really important to understand here is that when you publish in a journal or on the internet, you are giving your invention free to the world. It is a disclosure, and that date becomes the priority date. So an inventor can file for a US patent application up 12 months later, and after that, it's too late. Public disclosures can also cause failures in international applications. So one, inventions are important for impact. And two, TLA is there to help. What you don't want to do is be the reason why you cannot get a patent later, meaning your own disclosure now is the prior art that the patent examiner uses later to deny your patent. So this is important because one can, you can disclose all sorts of things today via media. And so if there's any errors, Doug, please feel free to correct here. There's quite a lot of information. So in terms of provisional patent application, if the disclosures are worthwhile, the next step is usually to file a PPA. So sometimes several disclosures can be combined into one patent. or it can be separate. Provisional applications are a means to establish an early effective filing date, and they allow the term patent pending. So a PPA does not mean an automatic patent application will occur. So it allows a 12-month pendency period to file non-provisional US patent application or a PCT application, which is PCT stands for Patent Corporation Treaty. And it's an international law treaty allowing a single international patent application to seek protection simultaneously in over 150 countries. And so it allows another 18 months to pursue a patent in the individual country or region. And so at this point, once you've disclosed and you're looking at PPAs, it's a good time to understand claims, if you don't already, as this is what patents are all about. It's about the claims. So after the filing of the provisional patent application, and if there is sufficient data and it's worth it to continue, and that's all with TLA that you discuss with your licensing manager, then a regular application would be next. Worth it meaning the invention is novel, non-obvious, and useful. So you'll hear this over and over again. So non-obvious meaning someone skilled in the art, for example, myself as a scientist. If I read a patent from USPTO, right, the United States Patent Trademark Office, or WIPO, which is international site, one can read a lot. One can learn a lot from reading patents. So my invention cannot be obvious. So if I'm reading one patent, for example, about essential oils to preserve beverages by PepsiCo or Coca-Cola, and another about essential oils to kill mold, it would be obvious for me to think that essential oils would reduce microorganisms on food. This is not to say that I can't put in a patent application if I was on my own on essential oils. One can put in any application, it's just that they would be denied. I would have to prove our case that our specific combinations of essential oils and plant extracts are novel. So no prior art, meaning public disclosures, just like mentioned earlier, whether it's publications, internet, abstracts. If I was to sell a sample and put ingredients on there, that's considered a disclosure as well. And it's non-obvious, meaning that I just combine a few patents together and then filed. So the most important section of the patent is the claim section. And so claims define the exclusive right granted to the patent applicant. And the rest, whether you're giving examples or drawings, are to facilitate understanding of the claim invention. So claims are what tells third parties what they can and cannot do. And legally, the claims established outlines of any legal rights after the patent has been granted. And patents are important because many companies will not manufacture something unless it's protected by a patent. And some have less interest unless there are also patents in the countries that they're interested in. Therefore, having connections to industry is very important. This is a screenshot from USPTO's website. One can easily search patents on their website. So here I just had to type Janes, Joens, and Theoret, and this would bring this patent up. This was the first patent I was involved in, and this is a search in the patent application section rather than the patents already granted section. So even if the patent is abandoned, like this one was, the information is still published and is considered free to the world. So it's still a disclosure. And if we look here, it's a patent application. So it doesn't say, for example, US patent and then a number here. It's an application. And so the title is here, Campylobacter pillus protein compositions and methods, basically coding and amino acid sequences related to a pillus protein in order to elicit immune response, so basically for a vaccine. The inventors are listed. So ownership is the U of A, right? And the inventors assign it to U of A. So Lynn Janes, James Theoret, Ryan Reeser, and myself. And Ryan and James were graduate students at that time. And down here, this particular application was filed December 1st, 2006. And PCT, so the right to file internationally with the one application, is also December 1st, 2006. So the PPA went in 2005. So there's a lot of information you can get from just reading, looking it up on USPTO. So first, publications, including applications, patent applications that are abandoned are still considered disclosures. Second, back then, Tech Launch Arizona, or it wasn't called Tech Launch Arizona, it was called Office of Tech Transfer. It was in a different building by Marriott Hotel by Main Gate Square, and it was very small. So I don't think it was more than a dozen staff, possibly. And there was not much funding available back then because though innovation was important, it was much more of a priority today. So this particular application was funded because we had a vaccine company interested, and we did have a research agreement with that company for I think it was $200,000 or $250,000 with an option to license. So they did pay $20,000 or $25,000 for that right to be the one to either license the technology or to deny the technology, and then we can offer it to someone else. However, what we thought was pillis, once better electron microscopy equipment came in, was not pillis. And though the gene was still valuable, due to lack of funds, the European Union patent application was abandoned. However, another vaccine company shortly after was interested, but then would not license it because they did not want to be restricted to the US market. So these things do happen. So, lesson learned. But we did use this gene later on, which was combined into another patent. Here, so here I wanted to show this particular example because so that you could see this is like number 2, these are claims. So, this patent claims this particular nucleic acid molecule. So number 2 you see is canceled, number 6 is canceled. So you wouldn't see this if the patent was issued because you just see the claims that were allowed, with the notice of allowance. So this, because it was abandoned, is like in the middle of the process. So it was a back and forth process with the patent examiner via the lawyer. So for each claim, you have to prove that it's novel, it's non-obvious, and it's useful. Novel, meaning hasn't been disclosed somewhere, and non-obvious, meaning it wasn't combined somewhere from someone who could just read several things and know that would possibly work. This is the next patent, and this is a screenshot also from USPTO website. But this one is from patents issued, and I decided to show this one because it's complete, and the patent license in PCS is undergoing patent prosecution, so I didn't want to put them here. But here, just so that you can see that once it's issued, you see the number and when it was issued or granted. You always see the title, Campylobacter immunogenic compositions and uses thereof. You see the abstract. This one's very short, basically combinations of immunogenic compositions to generate immune response against Campylobacter to reduce colonization. You see the inventors, so Lynn James, myself, and Alex Armstrong. And so Alex was a graduate student when we first started with the disclosure. And she was the chair of the UA Food Safety Consortium after Lynn. And here, if we continue, once again, ownership is by border regions, right? Arizona border regions. And if you come down here, these are the PPAs, right? The patent, provisional patent applications. So we filed one in February 1st, 2012, and filed another one May 29, 2012, because we needed to add more information. But it's the first one that has a priority date, right? The disclosure. And so then we needed to file the actual non-provisional application within 12 months. So that's where you see the February 1st, 2013, as well as the international February 1st, 2013, the number for the PCT and the publication date for the PCT. So here we had filed for Brazil, China, European Union, and US. And I'm not going to go through all these. These are the first 10 claims, basically combinations of Campylobacter antigens to elicit immune response. And though this probably looks like gibberish, I wanted to point out a few things. So at that time, this is my second patent, and the first one was not written very well. So this one is much better written because there was more funding. And so though I still obviously need to learn a lot more about patents, I knew that in the first set of patent claims, one always tries to fit as much as you can. All right, so because then it's for the patent examiner to throw them out. So, but of course it has to make sense. So if you look at number 8 here, right? So we knew already that it would be a salmonella vector that would carry the Campylobacter antigens. But here we'd say the vector or carrier cell can also be Listeria, can also be Shigella, can also be Lactobacillus, right? So we listed the others. And then if you go to number 10, what I did was I took all the antigens we worked with, as well as in the literature, and had Alex do a lit search as well, because unfortunately Lynn had passed away in November and this deadline was 2 months later. So we were on our own. And so I had listed the different combinations there. And looking back, the patent was good, so I'm pleased with the outcome. And there have been 2 more US patents issued in this family, divisional patents, one in 2018 and one in 2020. So it's common to put a lot into the claims, and often the patent examiner views the section as multiple inventions. So you can continue to keep having the right to keep putting in applications. And so, for example, this is a compositional application, meaning that it's formulations versus methods. So if you put one in for compositions and methods of using it, it isn't uncommon that they will break that into 2. So one for composition, and then you apply for another patent for the methods. And back then I had Roy Curtis and Ken Rowland, both vaccine experts, with patents already. They read it and they thought it was fine. So I would highly recommend having others skilled in the field read it if you're unsure. These lawyers now, or back in, this is 2012, are much better than ones in 2006. And it's still good to remember that lawyers provide more the legal view. And to remember that the inventors are the person or persons, usually persons, who contributed to the claims. So the formation of the concept in the mind of the inventor, so not necessarily the implementer or the person who did the work. And you don't need to do the work to include the claim, like every single particular item that you put in. So we didn't have to have examples for example, every essential oil that we put in there. And in this case, every single antigen that I've added here. So if the implementer or who's doing the work added a feature that is substantive and adds additional claims, then they're also an inventor. And if someone assists you in your patent claims and adds claims, they're also considered inventors. So far, I'm still talking about as an inventor or / contributor on the University of Arizona side. So, once you've disclosed and you have the PPA and it's doing its conversion to a patent application, and then it gets issued. So, actually, I forgot to, I'm sorry. Here, so let's go back here in terms of dates. So first filing was 2012, right? 2013, we put in the PPA, and then it's issued in 2016. So you can see that the process takes quite a bit of time. So pending, of course, doesn't necessarily mean issued. In terms of data, they're asset development funding from Technology Arizona. So these are to achieve very specific milestones towards commercialization. So for research and development, it's on the D for the development. So definitely not like a fishing expedition, but a very specific milestone so that it increases the value of your intellectual property so that companies would be interested in a research agreement. I received one in 2015, one to further test the Campy vaccine and one to test swine dysentery vaccine. 2018, Sadna and I received one specifically to test our antimicrobial to see how much shelf life was increased in terms of our produce. And so the longer, of course, shelf life was increased, the more value the patent would be. And persons from industry often give input to these asset development projects, and they range, I think the average is like 40 or 50,000. So asset development funding from TLA. And also there can be enough data to attract industry funding for a company that, for example, company X wants to work with you and they are wanting to know a particular question with your research. So the research can be conducted at U of A. So they sign a research agreement that lists the intellectual property involved, the scope of work, and the budget. And here, the research agreement currently has a 62.5% indirect fee. So if I need 100,000 to do the work, company X would need to agree to a budget of 162,500. And then sometimes the company just wants to license the intellectual property. So company X says, you know what, I really think that I'm interested in, or it's ready for development, and I want to have exclusive rights to your patent so that I can take where you have gotten it to, and I'll take it and I'll develop and manufacture and sell it. So here they sign a term sheet listing all the details, such as how much the company X would pay U of A, what diligence milestones need to be met, and et cetera in the contract in terms of what needs to be done to have exclusive rights. And it doesn't have to be exclusive right. It just, the ones I've been involved in usually are. And the field of use, you have to figure out exactly what field of use is it's for. Like for vaccine, it's like, is it chickens? Is it pigs, humans, you know? For sanitizer, for example, disinfectant, or it could be all uses. So in terms of as a UA employee, the first step is the disclosure. And then once there's enough data and it makes sense to have a provisional patent application, a conversion afterwards to a regular application. And if there is no application, then that PPA just goes away, right? So US patent and possibly a PCT filed for internationally. And then once you filed it, you just have these office actions that come back and forth in terms of the claims, which ones need to be, which ones you need to defend, and eventually which ones they will allow. So notice of allowance to say that which ones they're issuing. There's asset development funding, and then there's a decision whether at this point, whether you want to launch a startup or you want to just license it to company X, for example, to do all the work. This is from TLA's website. So when UA receives income, net income that is, after, you know, there's administration fees and any remaining fees, this is the distribution chart for inventors, and contributor is that means inventor. So this means the people that are the inventors on the claims on the patent, and it doesn't have to be people from UA. So if you have people from outside of UA, then it also includes them. And in Lynn's case, for example, because he is deceased, then this would just go to his children. And so if the amount is less than 100,000, 50% goes to the contributor, usually contributors, and it's prorated according to whatever you have, the group has decided upon. A contributor discretionary account is, you know, those that have a lab, so it goes into a discretionary account. And then fund for promotion of research is the 20%. The 100,000 to 500,000, then the distribution changes to 40% for contributors, 25% for the discretionary account, 25% for promotion of research, and then it goes 5% each to department and dean's account. And then above 500,000, so this is once again for net income, it changes to this distribution. So 30% for contributor, 15% for discretionary account, 30% for the fund for promotion of research, 15% to the department, and 10% to the dean's account. So international filings are expensive. So more is not necessarily better. US patent total fees, you know, I think the average is like 14,000, 15,000, but it can go up to 20,000 depending on the complexity. International can bring that figure easily to 50,000 pretty quickly and over 100,000. So, you know, those expenses need to be paid. And companies that license, you know, that's part of it. So far I've listed the steps as inventors here at UA. So those that contribute to claims on a patent. So this doesn't necessarily have anything to do with founders. Okay, so I think when I first started, it was confusing because you could way long time ago, it could be one or the other. Whereas now you could be both. So they're not mutually exclusive. So you put in disclosure, you contribute to the claims, now you're an inventor, right, to a patent. Now, if you decide to have a UA startup, then you become a founder. So that means ownership or equity of a company, whether it's a limited liability company or incorporation. And so, like I said, one can be both. So an inventor such as myself and Sana, we decided to launch a UA startup, PCS. So now we're also founders of PCS. And so PCS is now like company X, right? So we negotiate the license agreement with TLA. So in terms of the vaccine technology, that went through two startups. The first, Anivac, ANIVAC, with only Lynn and I as founders. The second, Anivax, with Alex Armstrong, Mike Anderson, myself, and John Buttery as CEO. The second one did not work out because the CEO and I did not agree on fundamental things. And one would think that we would know that in the beginning. And today I would probably see red flags better. But I would caution you to be very careful who you allow into your company, as it's not easy to dissolve things. So finally, decided to license the vaccine technology to an outside party, so people I truly trust, and they are responsible for the past patent expenses and of course future patent expenses, and responsible for the diligence milestones. They have received an SBI grant to further develop the vaccine, so hopefully that goes well. So now we switch over to founders, right? So those are all the steps for the inventors. And then founders, if you want to do a UA startup. Now, if you don't know if you want to launch a startup or not, there's a great NSF I-Corps program at TLA where you go through a process of customer discovery where you interview 25 customers, which can be individuals or companies, depending on what your technology is. And so you're not going to go say to them, I have a great technology, but rather like we have, we're in this field solving this problem. And do you see the same problem? How would you solve it? So it's to understand the market better to see if there's a demand. It's a 6-week program. Takes about 12 weeks to finish. And they fund $3,000 towards, the meeting with these customers and towards building a prototype. So very helpful. I really wish this was available back in 2006 or 2012. It would have helped me a lot. I did interview the top 3 companies. They did fly in and I did meet with all of them. But I think just going through the process would have been very helpful. So it helps you with go or no go, right? Would you like to be a founder or not in terms of UA startup? Now, as a founder, there are lots of conflict of interest paperwork. So just like you have to fill out paperwork every time you consult for a new company, you have to fill out paperwork to be a founder, as that is a financial and personal interest. And that needs to be managed with a management plan, and you need to submit an enabling disclosure. So this is my least favorite part. It's a lot of paperwork, but it is necessary and required legally. The best thing I'd recommend is to just keep everything separate, meaning lease a separate space on campus or an incubator. Don't have students work at your company. Have your lab do the research and the company conduct the development work. Because for every grant that you bring in, you have to actually kind of have the COI office understand the differences. So NSFI Corps, conflict of interest. Now, so you started your own company, PCS, for example, right? So now you're company X as well, and you need to license the patent so that you can use it exclusively. And so here in the license agreement, the terms are negotiable, except for a few state of Arizona requirements that are non-changeable. The license agreement will include things like previous patent costs that you need to take care of, future patent costs, a minimum annual royalty amount. So that's if, like, for example, and running royalties. So running royalties are, for example, if we have a product, a sanitizer that we're selling, And we agreed on a percentage, whether it's 4% or 6%. It really depends on what the product is and the profit margins for that particular market. So those running royalties will go to U of A. And if that minimum amount doesn't meet the minimum annual royalty amount, then that amount needs to be paid. And that's different. It gets higher and higher as the years go by, because one expects to be more successful as the years go by. So, whether it's 2,000, 5,000, 10, 20, 50, later on, running royalties, percentages, sub-licensing fees, milestone payments are, for example, for the vaccine, it's like 150,000 to be paid to U of A once USDA approves the vaccine, or in each country, or something like that. Or once sales of, let's say, 50 million or 100 million are reached, 1% to be paid to U of A are examples. In terms of diligence milestones, those are like what the company would need to do to show that they're diligent in developing the technology. So, for example, obtain an SBI grant within 2 years. That's very reasonable. And first commercial sale within 3 years. So those are examples of diligence milestones, so that the technology is being used and not just sitting there. So here it's important to have someone that has experience with these term sheets, which is not necessarily the lawyer. They are there to guide and to ensure legality of the contract, but not necessarily to know what milestones are appropriate for your own company, or percentage of sales, or things like that, for example. Oh, so are there any questions here before I switch over to introducing PCS?
If you have any questions, you can either enter them in the chat, or you can unmute yourself and you can come on video, and please feel free to ask questions. Thank you.
Bibiana, can I ask a quick question?
Yes. Is this Arun?
Yeah, this is Arun. I was just wondering, how was your experience with respect to resolving any COI issue? Did you face any challenges or anything specific you want to highlight?
Yes. So because, I don't remember it being as sticky years ago, but I think it's just growing. I think as we grow and we have more innovation and just so many people having more companies and startups, and it's just better to have things separated and be clear. So, for example, PCS, Sadhna cannot supervise me because of the involvement of PCS. So therefore, we needed another faculty to supervise me in a sense. So I know that sounds kind of, somebody else's, because my work, it's hard to know what I do unless you're in the lab. But that is something that you have to work out in terms of a management plan. So in our particular case, we're very happy to have you on board. We have to, one thing is to always keep your, department head in the loop, which we did. So, which is not a problem. And because they can also be the supervisor. But the management plan, what it does is that it manages the things that you can do in the lab without blending things. For students, for example, it's very important for students in terms of publications, right? But in terms of a startup, you might not necessarily want to publish because you don't want your secrets out there. And there are ways of publications where you can make the methods a bit more blurry, or you don't need to detail everything. And some publications kind of allow that more because they know. But for every student, the ones that have a thesis, for example, they need to publish. So you have to be clear how you're managing that conflict for the student, for your staff. And so for staff, that do work for both the company and U of A, that's where the management plan has to clearly state what they're doing. And if there's any conflicts, then there's someone they can go see in terms of the management plan.
Did you train the students to in a way that they understand inventorship and authorship difference?
Oh, well, we are not, in terms of, we're not going to have any students work,
Okay.
some at PCS and also at U of A, because it's just cleaner to have it separated. So our students right now, well, first of all, we haven't leased the space yet. So we only have 3 founders right now, and it's for one of the founders not U of A. So Sana, myself, and Daphne, which I'll introduce. So there's just 3 founders. Originally, we were going to have some staff members from U of A, from Sana's lab, like Libin and Richard, also start at the company. But because of the management plan, it makes it very, very sticky, because you have to actually list, you know, in terms of their FTE and their details and skills and what they're doing. And so it's easier just to separate that. So we're going to actually hire someone for PCS, completely separate for PCS. And the students that work for PCS will not be working for the UA side.
Thank you.
You're welcome.
Yeah, thank you, Dr. Dar, and thank you, Bibiana. We have one more question here from Charlene Aparicio. Where were your patent attorneys for each of your inventions located? Phoenix, Tucson, and how did you come to choose them?
Oh, they were actually chosen by TLA. So, but they were not in state. Well, you have different lawyers for different things. So patent lawyers is based on the area that what the patent is in. So, you know, molecular technology would have to be a particular one. And this one was sanitizers and in food safety. So I think one was in Washington. I mean, I had several, so I don't remember, but they were not in Tucson or Arizona. They were all across the nation, actually. And so they were chosen by TLA, and I do trust TLA, absolutely. So like I said, it's a great time to have inventions right now, because they are fully ready and geared to help you. They have all stages there. They have people to help you as the inventor. They have people to help you as the founder. They have all these programs that can help you on whichever side you are, or on both sides. In terms of lawyer for your company, though, that's a different story. They do have a list that they recommend. We chose our own. You know, that's in Chicago, because that's where our Daphne is. But even in their office might not be in Chicago, the lawyer themselves. Our strategy licensed person is in Chicago.
Yeah, thank you, Bibiana. She says thank you.
Oh, you're welcome. So, I mean, I would, you know, if you have to choose your own, like if you started your own company and it's not, and you, let's say PCS a year from now, we have our own inventions, right? So then I would have to choose our own lawyer. So I would go by references, you know, people that we knew, because it's always good. The people are always key, who you work with at this point. Any other questions?
I don't see any more.
Okay.
So, yeah, maybe we can continue, and then we can take, you know, another 5 minutes for questions maybe at the end. Yeah.
Okay.
Yeah, thank you.
I will hurry along because it's already 2:50. So I'm pleased to introduce Phytocentric Solutions, LLC. So our focus is on plant-made antimicrobials for an environmentally conscious planet. So I am the CEO. Sana is the Chief Science Officer, and Daphne Pruis, who's in Chicago, is our Chief Strategy Officer. I'll expand a bit more on Daphne since she's new, since a lot of you are familiar with Sana. And myself, I've given a background, some background details. So here, I like to stress that it's very important to have a highly experienced strategic person to help you. So Daphne helped with formation of the company. She helped us with registering PCS in Delaware, because Delaware has extensive case law in regards to corporate law, and lawyers are well versed in Delaware's business laws. Over 60% of all, you know, Fortune 500 companies and 50% of all public traded companies are incorporated in Delaware. Stephanie is experienced in the licensing process and helped negotiate our license. She has connections to assist with accounting, insurance, liability, payroll when needed. She has legal contacts. So costs are very reasonable and reduces a lot of the busy work from just having to be figured out. I mean, it took me, so much time to figure some of these things out in the past. She ran her own lab as a professor and successfully commercialized her technology, served as CEO for a decade, and had a very successful exit, as well as assisted many agricultural startups. So she has a lot of experience from pre-launch to exit. She's raised over 120 million. And most importantly, she's a good fit. So she's very careful who she works with. And that is key, like I said, in the end. And so there are people that help with startups, and they can definitely choose lawyers. We decided to launch PCS because the timing seemed right. In terms of consumers are increasingly conscious of their buying decisions. So they are aware that chemical processes and products cause harm to themselves and their families and humans and the environment. They are aware that supply chains impact health and the environment. Natural ingredients are highly valued today over synthetic ingredients, and they are manifested in many trends. We see organic and natural products in foods, in cleaners, in cosmetics, and also the pandemic. There's a huge and rapidly growing market driven by COVID-19 awareness. So that actually influenced our decision to start this company, because never before has there been such an acceptance of disinfectants and hand sanitizers and safety. So these are some of our market opportunities that we are focusing on. The first one is a produce sanitizer. So with the current practice is using chlorine. So it's the most common. However, it has disadvantages such as it's affected by organic load, plus continual additions are required. It has a max efficacy of 1.5 to 2 log reduction of foodborne pathogens. It does not have any residual activity, so it's mostly instant kill. It's hazardous and corrosive to equipment, and it's harmful to the environment, but it is very cheap. With PCS, so our sanitizer, produce sanitizer, is 100% plant-made microemulsions. And efficacy is not reduced by organic load. Reduction is up to 5 logs. It is recyclable with multiple batches, so the same water can be used. So instead of adding more chlorine to the water, the same water can actually be reused. It has residual activity. We've tested up to 28 days. So therefore it increases the shelf life. It prevents biofilms, and it's biodegradable and has health benefits, known to have health benefits. The next market opportunity is a surface sanitizer disinfectant. So just like produce sanitizer, chemicals are most common. So chlorine, clot products, acids, and these chemicals do not have residual activity. They are hazardous and corrosive and harmful to the environment. With our products, once again, efficacy not reduced by organic load, but it does have residual activity. So after spraying it as a surface disinfectant, it continues to work. It prevents biofilms. It's user-friendly scents, different type of scents because it's natural and it's plant-based. It's non-hazardous and non-corrosive, and it's biodegradable. Another market we're looking at is biofilm prevention. So currently in irrigation systems, ozone, hydrogen peroxide, and chlorine dioxide are used, and there are also chemical coatings that are used. Once again, ours not reduced by organic load, and not only does it prevent biofilm, it also has residual activity. So it's not just reduction. It's non-hazardous, biodegradable, and user-friendly scent. So I keep bringing up scent because in the NSFI Corps, one of the things that that surprised me that I didn't realize was how important scent was to consumers. In hand sanitizer as our next opportunity. So right now, currently, there are limited alternatives. They're either alcohol-based, which is the most common, or quat-based, and it causes hand dryness. So our PCS products are natural formulations. They're moisturizing. They have, once again, natural scents, and we can actually blend them with different types of natural ingredients, such as aloe or agave, for health properties. Details of our technology. So as I mentioned, this, I just want to see what time it was to make sure. We do have a US patent application, so it's not yet issued. We're going through the patent prosecution right now. In terms of some data, just very quickly, I'll go over just 2 slides. And here, this is survival of Salmonella Newport on iceberg lettuce treated with PCS with our microemulsions. So on the bottom line here is days of storage. On the y-axis, it's survivors of Salmonella. So if you'll just follow my pointer here. So the first one is the control. So it's simply iceberg lettuce inoculated with Salmonella. And obviously at day 28, there's still lots of it. But the second bar, the blue, is chlorine. So washed with chlorine, there's still Salmonella, day 28. The third control is hydrogen peroxide. So day 14, there's still Salmonella present. In terms of our proprietary microemulsions, starting at day 0, instant kill, there's already 2 that have taken it down to non-detectable. And by day 10, all of them work. This is the chart for survival of E. coli 01557 on iceberg lettuce. So iceberg lettuce that's been inoculated and then dip treated with our proprietary microemulsions and then stored at 4 Celsius for the very storage dates. And y-axis survivors of E. coli. So once again, the control, that's inoculated, iceberg lettuce inoculated with E. coli and not treated and then stored. Day 28, there's still E. coli surviving. With chlorine treatment, day 21, still E. coli surviving. With hydrogen peroxide, day 14, E. coli still surviving. With our PCS proprietary microemulsions, if you look at day 7, all of them worked, and instant kill, 2 of them already started working. So our mission is to develop plant-based antimicrobial products and provide research and testing services industry. We're identifying space on campus. There is space on chance. We will be hiring. We have licensed technology from UA to PCS just last week. And there is a media startup package, SCAD Media, provided as part of licensing agreement. So once again, compared to the past, a great time for entrepreneurship innovation. So they will assist with our startup package with logo and website. We are starting to meet with companies and currently seeking startup capital. And the current plan is to secure funding with SBIRs in competition. So basically non-dilutive funding so that we're not diluting the equity. We are looking for industry collaborations to test formulations in the commercial pilot testing, to advise us on relevant test conditions, and also to guide assessment of regulatory requirements to confirm our formulations are generally safe, as recognized as safe, because our ingredients are, we do need confirmation. And so that's a very quick introduction to PCS. Any questions? I don't have very little time left, but.
Well, thank you, Bibiana. Does anybody have any questions? Please, go ahead and speak up, or you can use the chat feature.
Oh, I see Doug here. Says TLA has more than 60 firms to choose from, and we can work with inventors to select the best attorneys for the technology and fit with inventors. So at the U of A, TLA has 60 law firms that they choose from, and I'm very happy with the last one.
Bibiana, this might be a silly question. I see this plant-based compounds that you have appears to have a lot of antibacterial activities, but in terms of using on the surface for surface cleaning purpose, does it leave any oily residues? Like, if I'm cleaning the surface and if I spray it, it might be very effective, but does it leave any oily residues or not?
We have to do more testing, but the concentrations that we use are very low. The beauty of our formulations is that is the combination that gives synergy in the reduction of the microorganisms. So it's actually a very low amount that we use. So I suspect not. Okay,
but with respect to application in food item like lettuce and others, does this compounds have any negative impact on the gut healthy microbiome? Do you know?
We did do some testing, and the results were actually very good. It was actually a good surprise. We were actually looking at shelf life. So we were testing Pseudomonas and Lactobacillus. And Pseudomonas, it did take it down, which is great. So less spoilage. And Lactobacillus, which is, you know, probiotic, it maintained it. So it did take it down, but it maintained it. So that was very nice to know. So it's you know, we of course would have to do more testing and research, but that, you know, the insight that we got was very good.
Okay. Thank you.
You're welcome.
Any other questions? Doug says, wow, great job, Bibiana. Thank you.
So if there's anything, you know, to correct or make clear, just go ahead. Doug is the Vice President of CLA, for those that don't know.
Any other questions? Great talk. Thank you for speaking. Thank you, Charlene Aparicio. All right. I know it's a long weekend. And so if there are no other questions, I would like to thank Bibiana for giving this presentation. Thank you, Bibiana, for taking this up in a very short notice and giving this seminar. So I'm, you know, clapping for you on everyone's behalf. Thank you. And thank you, all of you, for attending the presentation today. I know it's a long weekend, so I really appreciate all of you being here. And please stay tuned for another seminar from USDA. We will have a speaker from USDA, probably the week of July 26th. I don't have the date yet, but as soon as we know the date, we will inform you. And I hope everyone has a great 4th of July weekend. Take care, everyone. Thank you again.